A federal appeals panel just dropped an emergency ruling that landed like a hammer on the concealed carry permit system, and most people in this country still have no idea it happened. Every single judge on the panel agreed on the core holding, not one dissent, not one carve-out, not one hedge. In a body of law where 3-judge panels argue about commas, a unanimous decision against a state permitting framework is the kind of signal you cannot ignore, and it tells you exactly which direction the wind is blowing on the Second Amendment in 2026. This applies directly to states inside the panel's jurisdiction and indirectly to every state that runs a similar permit regime, which right now covers tens of millions of Americans who carry, want to carry, or have ever filled out a permit application. If you have ever gone through fingerprinting for a concealed carry license, paid the application fee, sat through the mandatory training, and waited months for a sheriff to sign off, this affects the legal ground under your feet. And the most shocking part of the whole thing is how quietly it landed. The mainstream outlets buried it. The cable shows skipped past it. The people who scream about constitutional rights every other day went silent the moment this one cut their way. If you are someone who actually takes your rights seriously, not just talks about them on social media, this channel was built for you. Hit subscribe and stay with me, because what comes next matters more than the headline. Here is what most channels will not tell you. This ruling did not appear out of nowhere. It is the latest aftershock from a much bigger earthquake that hit 4 years ago. In 2022, the Supreme Court decided New York State Rifle and Pistol Association versus Bruen. That decision struck down New York's proper cause requirement, the law that forced applicants to prove a special need for self-defense beyond just being a citizen, and in doing it, the court did something even bigger. It rewrote the test that every lower court has to use when it looks at any gun law. The new test is history and tradition. If a regulation does not have a clear analog in the founding-era record, it does not survive. That sounds technical, but the practical effect is enormous. Every may-issue regime in the country was instantly on borrowed time. Every sensitive place restriction, every fee structure, every discretionary denial got dragged back to the era of the founders for comparison. And most of them cannot find a match. Let me make the history and tradition test concrete, because everyone throws the phrase around and almost nobody explains what judges actually do with it. When a modern gun regulation gets challenged, the court asks one question. Was there a closely matching law on the books at the time the Second Amendment and the 14th Amendment were ratified? Not a vaguely related law, a regulation that imposes a comparable burden for a comparable purpose. If the state cannot produce that founding-era analog, the modern law fails. Discretionary permitting, where a bureaucrat gets to decide who deserves the right, has no clean historical match. Sweeping bans on carrying through ordinary commercial life have no clean historical match. Fee structures designed to make the right unaffordable have no clean historical match. That is why so many state regulations are folding one after the other. The historical record simply does not back them up. That is the legal earthquake. The emergency ruling you just heard about is one of the aftershocks, and there are bigger ones coming. The Supreme Court itself is sitting on a case right now called Wolford versus Lopez. Oral arguments happened in January of 2026, and a majority of justices openly questioned the logic behind Hawaii's concealed carry restrictions and its property owner consent rule. A decision is expected by late June of 2026, which means within weeks the highest court in the country could hand down something that reshapes the carry landscape even further. The panel ruling that just dropped is being watched closely as a preview of where Wolford might land. On the same day Wolford was argued at the Supreme Court, the Fourth Circuit Court of Appeals decided Kipke versus Moore. The Fourth Circuit struck down Maryland's expanded sensitive places law, the one that tried to ban concealed carry inside any private property held open to the public. That is, restaurants, gas stations, grocery stores, parking lots, basically the entire commercial fabric of daily life. The court said Maryland could not do that. The historical record does not support it. And that ruling came from a unanimous panel. Sound familiar? That is the exact same shape as the emergency ruling we are talking about today. A unified federal panel, a permit-adjacent framework, a history and tradition death sentence. The pattern is real. The pattern is the story. Now, before I get into the personal impact, I want to know what you think. Do you believe this ruling actually protects you? Or does it leave too many gaps wide open for the next round of restrictions to slide through? Drop your answer in the comments. While you are there, hit the like button. It is the single best signal I have to keep making videos like this. And it is free. Here is what most people are missing about what this actually means for your life. Before the wave of post-Bruen rulings, if you wanted to carry a concealed firearm in public, you had to go through your state government. You filled out the forms, submitted to the background check, paid the fees, completed the training, and waited. Some states made that process reasonable. Others, like the 4 remaining May-issue holdouts of California, Maryland, Massachusetts, and New Jersey, made it nearly impossible unless you were politically connected or carried the right last name. What this wave of rulings does is flip the entire premise. The government cannot require you to ask permission to exercise a right that already belongs to you by default. The right does not come from the state. The state did not grant it. The state did not invent it. So forcing you to beg for an official signature before you can use it is backwards on its face. The analogy that keeps coming up in the comments is the right one. Imagine the government required a permit before you could post on social media. Imagine you had to apply, pay a fee, take a class, and wait 6 months before you were allowed to speak online. You would call it tyranny in 5 seconds flat. And yet that is exactly what the carry permit process has been for decades. The map of this country in 2026 already tells you most of the story. 29 states are now constitutional carry states. That means in those 29 states you do not need any permit at all to carry concealed if you are a law-abiding adult. The list reads like a sweep across the country. Alabama, Alaska, Arizona, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Mississippi, Missouri, Montana, Nebraska, New Hampshire, North Dakota, Ohio, Oklahoma, South Carolina, South Dakota, Tennessee, Texas, Utah, Vermont, West Virginia, and Wyoming. 29. 15 more states are shall issue, which means if you meet the statutory requirements, the state must issue your permit. That is Colorado, Connecticut, Delaware, Illinois, Michigan, Minnesota, Nevada, New Mexico, North Carolina, Oregon, Pennsylvania, Rhode Island, Virginia, Washington, and Wisconsin. Then you have 4 May-issue holdouts: California, Maryland, Massachusetts, New Jersey. Those 4 are where the post-Bruen litigation is most concentrated because that is where the gap between the new constitutional standard and the old state framework is the widest. Here is another layer most people never think about. What happens to the permit you already have? That is one of the very first questions gun owners are asking, and there is no clean, single answer yet. The rulings address the requirement to obtain a permit going forward. Whether they invalidate existing permits depends on how individual states respond and how state courts handle the transition. Some states will dismantle their permit machinery quickly because they read the writing on the wall. Others will fight to keep their existing systems running under new legal theories. And that second group is where things get tangled, because courts are already watching for lawmakers who try to replace the permit system with something that does the same job under a different name. New label, same restriction, same result. The judges are not going to fall for it. Now let me walk you through what your life might actually look like in the coming months. There are 3 realistic scenarios you could face, and you need to think through each one carefully. Scenario 1. You live in a state that ran a May-issue permit system. That means the state had wide discretion to deny your application for any reason or no reason at all. Local sheriffs could say no based on personal judgment, and you had almost no recourse. They looked at your background, weighed your stated reason for wanting to carry, and decided whether you deserved the right. That system is gone, or it is being dismantled in real time. You no longer ask their permission. The burden has shifted to the government to prove you should not be allowed, rather than you having to prove you should. That is not a tweak. That is a complete inversion of how the burden of proof works on a constitutional right. Scenario 2. You live in a shall-issue state with mandatory training, a waiting period, fees, and sometimes additional requirements like fingerprints or interviews. Those requirements are now under serious legal pressure. You might still need to complete training to handle a firearm safely. And honestly, you absolutely should, for your own protection and for everyone around you. But the government cannot hold your constitutional right hostage to a bureaucratic process designed to discourage you from exercising it. Your options for carrying legally just expanded significantly. The open question is whether your state will try to rebuild the old system with new restrictions dressed up in different language. Scenario 3. You travel between states with your firearm. This is where it gets tricky and where you need to pay the closest attention. Not every state is covered by the same ruling. Constitutional carry in your home state does not automatically extend across state lines. A top comment on the original video nailed this exact pain point. The same person pointed out that if you get married in New York, you are still married in Texas. If you have a New York driver's license, you can drive across the entire country. So why is your Florida concealed carry permit not legal in New York? The answer is messy. Marriage and driving licenses fall under the full faith and credit clause and decades of established reciprocity practice. Concealed carry sits in a different legal corner where each state still asserts its own authority. That is exactly the wall the post-Bruen wave is hitting next. National reciprocity has been a political fight for years, but the litigation track is now starting to do some of the work that legislation could not. Until that fully shakes out, you need to know the specific laws of every state you drive through. The map of where you can legally carry will look different in 6 months than it does today. Do not assume your current knowledge is still accurate even 30 days from now. Here is another scenario coming up everywhere. You walk into a business and see a sign that says, "No firearms allowed." Before the wave of rulings, that sign carried the full weight of state law backing it up. Now the picture is more complex. Private property rights still exist. Business owners still have the right to set rules for their own premises. But the Fourth Circuit's Kipke decision specifically struck down the version of this rule that flipped the default, requiring property owners to affirmatively post permission before a permit holder could enter armed. That kind of default no-carry rule is the one that just got cut down. Direct prohibition by an individual business is different from a blanket state-imposed presumption. How that line gets drawn over the next year will define what daily life looks like for every carrier in America. Now let me address what you are going to hear from people online who did not actually watch this video carefully. There is a lot of noise circulating, and most of it is either wrong or dangerously incomplete. Myth 1. People are saying this ruling means you can now carry a firearm anywhere with zero restrictions. That is absolutely not what happened. The ruling addresses permitting and sensitive places overreach. It does not eliminate the long-standing federal restrictions on carrying inside federal buildings, schools, airports, courthouses, and private property, where the owner explicitly says no. Those rules still apply. Violating them still carries serious criminal consequences. This ruling changes who gets to carry. It does not change the very narrow list of places where carrying remains off-limits. Two completely different things. Myth 2. Some people are claiming this ruling has already been stayed or blocked by a higher court. As of right now, the panel decision has not been overturned. The case is moving through the system. There will be appeals, there will be motions. But what is in place today is real. It is in effect. Do not let anyone tell you it does not exist or has been quietly reversed. Follow this channel and I will tell you the moment it changes. Myth 3. Friends and family members are telling each other that existing permits are now completely invalid and should be thrown away. That is premature and potentially dangerous advice. Your existing permit may still serve you in states that are not yet directly affected. It may still give you a legal benefit when interacting with law enforcement officers more familiar with the old system. It may still open doors in states that maintain their own permit requirements under state constitutional authority. And it may still be your reciprocity ticket when you cross state lines. Do not assume your permit is worthless. Keep it. Understand when it applies. Use it intelligently. Myth 4. People are saying this applies to all 50 states immediately. It does not. The ruling applies directly to states under the jurisdiction of the panel that issued it. Other states are affected indirectly through the precedent it sets, but the binding direct application is narrower than the headlines suggest. You need to know which category your state falls into. That is not a detail. That is the difference between legal and illegal. There is one more thing every comment thread keeps asking about, and I want to put it on the table clearly. Background checks. Striking down a permit to carry requirement is not the same as striking down the background check system. The National Instant Criminal Background Check System still operates. Federally licensed dealers still run a check before transferring a firearm. People prohibited under federal law, convicted felons, those subject to qualifying restraining orders, individuals adjudicated mentally ill, are still prohibited from possessing a firearm at all, permit or no permit. The carry permit reform and the background check infrastructure are two separate tracks. Do not confuse them. The right to carry does not erase the disqualifications that already exist in federal law. Here is what I want you to take away from this entire video. 3 things. Remember them above everything else. Number 1. The legal architecture has flipped on who carries the burden of proof. Before, you had to prove you deserved to exercise your right. You had to demonstrate good cause, show specific need, and persuade a government official whose discretion was the final word. Now the government has to prove you should not be allowed to exercise that right. They have to show you are dangerous, that you have lost your eligibility, or that there is a specific lawful reason to prohibit you from carrying. That is a massive inversion. It changes the entire balance of every conversation between a citizen and the state when it comes to the Second Amendment. Number 2. The permitting structure as we knew it is under serious legal pressure across the entire country. Even if this specific panel ruling gets modified on appeal, even if it gets narrowed or delayed by a stay, the direction of travel is unmistakable. Courts are more receptive to Second Amendment challenges than at any point in the last 50 years. With Wolford pending at the Supreme Court, with the Fourth Circuit's Kipke decision on the books, and with this new emergency panel ruling joining the chain, the legal environment has shifted, and it is not shifting back. Every gun owner needs to understand that the world we are moving into is not the world we came from. Number 3. Your responsibility just increased significantly. More people will be legally armed in more places. That raises the stakes for every gun owner to train properly, to know the laws in every state you set foot in, and to carry yourself with the discipline that comes from holding someone's safety in your hands. The right to carry is not just about you, it is about everyone within range when you decide to draw, or when you decide to walk away. When you carry, you represent every other lawful carrier in this country. Conduct yourself accordingly. So what do you actually do this week? First, look up exactly which category your state falls into: constitutional carry, shall issue, or one of the 4 may issue holdouts. Then look up the panel ruling and the circuit it came out of so you know whether your state sits inside that direct jurisdiction or only catches the indirect precedent wave. Second, if you already hold a permit, keep it active and keep it on you. The reciprocity value alone is worth more than the renewal fee. Third, if you have been putting off training because the bureaucracy made you give up, this is your moment. The legal barrier just got cut down, but the responsibility barrier did not. Find a serious instructor, run live-fire drills, learn the use of force law in your state, and study the de-escalation principles that keep encounters from ever reaching a draw. Fourth, sign up for legal defense coverage. The number of carriers about to enter public life without ever having read a single self-defense statute is going up, and the prosecutors who built their careers on cases where carriers froze in interviews are still at their desks. The attorneys who argued the recent cases have called this one of the most significant Second Amendment moments in generations. They are not exaggerating. What is happening is not a legal decision about paperwork and permits. It is a structural recognition that constitutional rights do not become constitutional privileges just because the application process is long, the fee is high, and the bureaucracy is slow. The Second Amendment exists so that ordinary citizens can protect themselves, their families, and their communities. A system that makes you ask permission first, that requires government approval before you can exercise a natural right to self-defense, undermines the entire point of having that right at all. That is what the courts are finally saying out loud. This channel exists because information like this matters, and because too many people are getting blindsided by changes that affect their freedom. The mainstream media will not walk you through the Bruen framework. Cable news will not explain Wolford or Kipke. That is why I am here, that is why you are here, and that is why we need to stick together while the legal map of this country gets redrawn in real time. Nobody is going to hand you this information. You have to find it, learn it, and use it. Subscribe, turn on the bell, and let us keep building something the mainstream cannot ignore. Drop a comment with the part that surprised you most, and share this with someone who carries a firearm or who is about to start. The next 6 months are going to move fast. Stay with me, and you will not get caught off guard.